Hi, I'm Alan Berry, your personal injury attorney. And today, I want to talk to you about the two parts of every case. And without both of these pieces, you can't bring a claim. So listen carefully. To begin with, the first issue is something called liability. Liability means who's at fault, who caused the accident. So if we think about the most simple of circumstances with regard to automobile accidents and the most clear-cut cases of liability, let's think about someone who stopped at a stop sign, stopped at a red light, and the car in back of them smashes into them, hits them from behind. No question about who's at fault in that accident. And in Connecticut, as long as you are not backing up at 100 miles an hour, it doesn't make any difference how that car in back of you hit you. As long as they hit you from behind, they have liability. So liability is a really, really important question. But sometimes liability is not that clear cut. Sometimes liability involves things like automobile accidents where there's an intersection and somebody says, I had a green light. The other person says, I had a green light. And there can be a dispute about that. Or one person says, yeah, maybe you had a green light, but the other car was speeding or something of that nature. Liability sometimes is not always that clear. Liability in cases where we slip and fall or trip and fall on somebody else's property, oh my gosh, that is a completely different story. In Connecticut, juries have not been really favorable to people that bring claims where they slip and fall on somebody else's property. Why? Because of what I call the coulda, woulda, shoulda. If you could have been looking where you were going, if you saw that there was a problem, you should have walked around it. These are easy things to say, but oftentimes we're walking, for example, middle of the winter, black ice. How could you possibly see there was black ice and you slipped and fell? I'm just telling you that liability in those kinds of cases is always contested. The insurance companies in those cases never want to pay voluntarily. There's always a big argument. So liability is the first issue in any case. If we don't have liability, sorry to say, it doesn't make any difference what happened to you. You don't have a case. So let's move on from there. Let's assume that there's liability, okay? And so the next part is something called damages. There are two kinds of damages, objective and subjective. Objective damages are the things that we can see and feel and touch and really easily understand, such as medical bills, x-rays, any kind of diagnostic tests, and out-of-pocket expenses like co-pays or deductibles or rental cars or things of that nature. So those are objective damages, and those things are really easy to figure out. And in fact, anybody could get compensated for that stuff because assuming there's liability, here it is. It's on paper. These other issues. The other kind of damages are called subjective. And I got to tell you, at Allen Berry & Associates, that's really, really what we're about. Subjective damages are pain and suffering, the impact on your life, how this affected you at the time of the accident, during whatever treatment you got, and how it's going to affect you out into the future. Those are really, really important considerations, and those are the things that we really want to take our time to think about and to talk about. Now, in other videos, I've talked about the calculation of values based on damages, so I'm not going to go into that today, but I just wanted to let you know, if you've been injured, there's two parts, liability and damages. Got to have both those things to bring a claim. As always, thanks so much for watching. I look forward to talking to you the next time.